from High Court in Karnataka that has dismissed a petition that was filed by social media platform X. The petition had challenged the centre's orders to block certain social media content. Justice M. Nagaprasanna, pronouncing the verdict, upheld the centre's authority under the IT Act to regulate online platforms in the interest of public order and safety. My colleague Imran joins us for more. Imran, what was this content that the centre sought to be blocked, and what is the petition all about?
Well, there are several social media handles which were blocked in the Sahyog portal, and over this X Corporation had gone to court challenging over it. In fact, the union government had directed the YES to regulate these blockage, in fact sent the directives. Over this for almost 6 months now the case was going on. Now the judgment has been pronounced by Justice Nagaprasanna, saying that social media content needs to be regulated. It cannot be absolute freedom of speech. In fact, during the hearing the court also said that regarding the freedoms of speech, the jurisprudence has gone more further, and High Court has a different view on it now than what was perceived earlier. It also said that a foreign entity cannot claim freedom of speech under Article 19, saying that the X Corporation is not based out of India but abroad. Hence, it cannot claim freedom of speech under Article 19 of Constitution of India. So, very setback to the social media companies X, formerly known as Twitter, over this freedom of speech issue, where they had challenged the certain blocking directives given by the Sahyog portal by the Union Government of India. High Court has clearly said that the petition does not sustain, and it dismissed it, saying that social media needs to be regulated, and X cannot claim freedom under Article 9 of freedom of speech because it's a foreign entity.
This is not the first time there has been a clash between social media platforms and the centre when it comes to certain regulations that the centre seeks to impose on the content that is posted on these platforms. In that context, Imran, it is very, very significant if the High Court today says that the freedom of speech is not an absolute right.
Well, absolutely. In fact, the High Court observed that there has been the difference of jurisprudences there about freedom of speech is concerned. What was earlier pursued as by natural rights. It's not also said that we have High Court have a much more nuanced view over this, because the mediums have changed, and the social media is one which needs to be regulated, is what the High Court said. And it said in that basis, they said that social media content sometimes can be very vile, can be very, very personal and targetive. Hence, it needs to be regulated, is what the High Court said. And it's hearing that it dismissed the social media company X's petition in that case, which is a challenge about certain directives issued by the central government to block certain social media handles which it pursued were anti-India and also disruptive in nature.
Now it's clearly a big setback for the big social media giant platform X. What has been their argument while opposing the centre's regulatory move?
Well, they had claimed that it's a freedom of speech is absolute, and it's also enshrined in the Article 19 of the Constitution of India. And it says that what centre has done, it's gagging of voices and which are critics of the centre, and it could also lead to further implications on social media, which upholds the freedom of speech. It also said that this is how authoritarian regimes across the country, across the world are doing it, and they said that this will fundamentally infringe upon the fundamental rights of the citizen. However, that is been set aside, recommending, as I said earlier, High Court said the jurisprudence over it has seen much more progress from there, and it sees things like which is very nuanced because the medium has changed. But he said that content on social media needs to be regulated. Hence, it has upheld the centre's directive over this and dismissed X's.
All right, stay on with me, Imran, because we are now joined by Pawan Dugal. Sir, what do you make of this verdict coming from Karnataka High Court, where the court has said that the freedom of speech online is not absolute? Well, we'll try and get in touch with the experts, but that is the verdict that has come right now from Karnataka High Court, clearly establishing centre's authority to regulate content online so as to curb its harmful impact. Moving on, Bengaluru, the vibrant IT capital, a city that proudly boasts